This is TWiT.
Supreme Court. Kind of, you know, this was a big decision that I didn't think got a lot of coverage. The Lexmark case. So this was decided in the Supreme Court this week by an 8-0 vote. The Supreme Court was hearing a case about a company that was reselling, taking Lexmark cartridges, refilling them.
These are printer cartridges?
Printer cartridges, inkjet cartridges. A company named Impression Products was refilling them. Lexmark sued, saying we have the patent on this and you can't refill them. The Supreme Court decided against Lexmark by 8-0. Actually, it ended up being revised because Ruth Bader Ginsburg said, well, okay, yeah, I agree, except it should be U.S. only. The 8-0 decision was originally U.S. and overseas. The point being that a patent and patent rights expire upon sale. In other words, if you buy something, you own it. This is huge.
This is a big deal.
This is a big deal. I was surprised to get more coverage, maybe because it seems so technical, but I think
it's got the word Lexmark in it.
Well, so where else does it apply that it becomes huge?
Well, I think it has a lot to do with the right to repair movement, right? Because Apple, for instance, would very much like you to have to buy repairs and parts from Apple.
Right. That's why they used weird screws.
Right. This would, I would think, could be used to defend people who say, no, you own that phone.
Is it going to hold up when we actually have like fully self-aware robots that we can buy?
You know, you ask a really interesting question. Maybe we should just wait and ask the self-aware robots.
We should.
Yeah.
We should wait until they're on the Supreme Court.
When they're on the Supreme Court. You know, I think it's time. By the way, I want a robot rights. It's time we got a self-aware robot on the Supreme Court.
Absolutely. The government jobs, forget the truckers. It's the government jobs that should be the first to go.
I think you're right. If you've ever been to DMV lately, oh boy.